Dear Mr. Yan Wanming, Vice President of the Supreme People's Court, dear Mr. Li Shenggang, Assistant Minister of Commerce, dear Ms. Gao Yan, Chair of CCPIT, dear Mr. Lu Pengqi, Vice Chairman of CCPIT, dear friends and colleagues, I would like to thank the organizers of the China Arbitration Summit 2020 for inviting me to deliver this speech in occasion of this important conference, which, due to the time difference with Europe, has to be recorded. I am deeply sorry for being unable, due to COVID, to be physically present in China in this occasion, and hope to have soon the opportunity to meet all of you personally again in your great country. COVID has already deeply changed the practice of international arbitration for parties and for institutions. To the ICC, it has been a particularly difficult challenge. The ICC organizes, on average, every year, about 150 court sessions in multiple locations on the globe, in the occasion of which more than 500 awards are scrutinized and thousands of decisions are made. Each of these court sessions involve from 3 to 50 court members, depending on the format, committees, special committees, or plenaries. The court has been able to completely reorganize its internal work so as to allow all members of the Secretariat to work remotely and all court sessions to take place by video conference, so that in spite of the pandemic, the work of the court has proceeded without added delays to the parties. Equally, our training activities, which are so important to the development of future generations of arbitrators, have continued online in all continents. We are nonetheless acutely aware that in many emerging countries, the personal contact and exchange is extremely important to the development and training of new generations of arbitrators, and we will need to resume our personal presence as soon as COVID will permit. COVID has presented even greater challenges to arbitrators and parties. All players are becoming more and more familiar with the technology, and technology will continue to improve so that even long and complex evidentiary hearings can now be organized remotely in a stable and secure manner, essentially under 3 conditions. The first is that the tribunal engages as early as possible in consultations with the parties as to the need and appropriateness of holding the hearing remotely. The second is the selection of a state-of-the-art platform, allowing the necessary functionalities such as manipulation of documents or conferences between the arbitrators, as well as technical support and the organization of testing before the hearing. And the third is the establishment of an appropriate cyber protocol, recording the agreement reached between the parties and the tribunal for the organization of the hearing. The ICC is also providing technical support to the parties, and the ICC Hearing Center can assist in the organization of virtual hearings. The ICC Court will soon offer a new platform allowing parties to upload and manage their submissions and exhibits online. The ICC finally has provided guidance to parties and tribunals in its COVID-19 practice note, which has been issued in March of this year, including a model cyber protocol that has been very well received by the arbitration community. The ICC COVID-19 practice note encourages parties and tribunals to discuss and implement measures aimed at mitigating the delays that may be generated by hearing postponements due to COVID-19. Virtual hearings are uncontroversial as far as case management conferences are concerned. They are also widely accepted in the context of urgent proceedings such as emergency arbitration under the ICC rules or proceedings related to dispositive motions. For large and complex evidentiary hearings, however, the organization of a hearing by video conference requires extra care, consideration of all relevant circumstances, and a careful consultation with the parties, in particular when one of the parties objects. While a party should not be entitled to delay the outcome of the arbitration by objecting to the organization of an evidentiary hearing virtually, a virtual hearing should not be organized for the convenience of the tribunal or result in a significant disadvantage for one of the parties. There is no way back. Technology will remain a fundamental aspect of the efficient conduct of any arbitration. And as technology improves, it will more and more be so. Holding a hearing online should no longer be considered as an exception or a departure from normal procedures. It will more and more be considered on the same footing as a physical hearing and will become an item in the agenda of any case management conference. In the post-COVID world, arbitration will move decisively away from its current pervasive culture of paper. Becoming greener is another way for arbitration to contribute to a better future for the world. The ICC is fully committed to that goal. Thank you very much for your attention, and I wish you a fruitful and successful conference.